Understanding the difference between proposals and contracts can save you from significant legal headaches. Many business owners and professionals often wonder, is a proposal legally binding? The short answer is no, not inherently, but the full answer requires more explanation. A contract is a legally binding agreement that contains specific elements: an offer, acceptance of that offer, consideration or exchange of value, competency of all parties involved, and legality of purpose. When all these elements are present and the document is signed by all parties, you have an enforceable contract. A proposal, on the other hand, is typically a preliminary document that outlines project details, services, or goods to be provided. It serves as a persuasive tool to secure business, but doesn't create legal obligations by itself. Proposals lack the mutual assent and consideration required for a binding contract. The distinction matters because proposals and contracts serve different purposes in business relationships. Proposals aim to convince potential clients or partners to work with you, while contracts formalize the agreed terms and create enforceable obligations. So, when might a proposal become legally binding? This happens when the proposal includes all the necessary elements of a contract. If your proposal contains a clear offer, terms for acceptance, defined consideration like payment details, and is signed with legal intent by all parties, it could function as a contract. Converting a proposal into a contract requires several key modifications. You need to include detailed terms of service, specific obligations for both parties, payment structures, and termination clauses. The language must shift from persuasive to definitive, clearly stating what each party must do rather than what they could do. When drafting a contract based on a proposal, include as many project details as possible. This creates clarity and prevents misunderstandings about expectations. A well-written contract distributes liabilities equitably and protects all parties involved. A crucial element to include is a termination clause. This protects you if a client puts a project on hold or cancels it entirely. The clause should specify compensation for work already completed and potentially for opportunity costs. Regarding signatures, both traditional wet signatures and electronic signatures can make documents legally binding. Under laws like the Electronic Signatures in Global and National Commerce Act and the Uniform Electronic Transactions Act, e-signatures are valid for most business contracts. Digital signature platforms provide authentication and audit trails that can strengthen enforceability. However, some jurisdictions still require handwritten signatures for certain documents like wills or real estate deeds. For standard business proposals and contracts, electronic signatures offer convenience without sacrificing legal validity. To make your proposal more contract-like, include a clear scope of work, specific payment terms, legal clauses covering liability and governing law, explicit acceptance language, and signature lines for all parties. These elements strengthen the legal standing of your document. Remember that contracts and proposals both serve to prevent financial disputes by eliminating ambiguity. The key difference lies in their binding power. Proposals can be withdrawn before acceptance, while contracts generally require mutual agreement to terminate. For important business dealings, consulting with a qualified attorney ensures your documents meet legal standards and protect your interests. A small investment in legal review can prevent costly disputes down the road. Understanding these distinctions helps you navigate business relationships more effectively and ensures that when you want to create binding obligations, you have the proper documentation in place.